Good afternoon. Today we're going to talk a little bit about justiciability, which is a big word. So, when we talk about what courts do, um, we often say that they resolve justiciable disputes by applying the law. And on Canvas, there's a fair amount of description about what we mean by the law. But let's talk a little bit about what we mean by justiciable disputes. So, the basic definition for justiciable is unfortunately circular, and a justiciable dispute is one that can be resolved by courts. But that doesn't get us very far. So let's talk about what sort of factors or characteristics make a dispute justiciable, make it something that the courts can resolve, as opposed to those features or characteristics that take a dispute outside of the realm of the courts. When we talk about justiciability, the sort of three big issues we look at are standing, whether there is a case or controversy, and something called political question doctrine. And we're going to look at each of these individually. So when we talk about standing, what we're interested in is who exactly is bringing the suit. Who is the person or the entity that is coming to the court and asking for assistance, asking for relief, asking to be made whole. And the person or entity that is coming to the court has to have standing, which means that the person has to experience what we call an injury in fact, meaning that you actually have been hurt or that you are about to be hurt by the law or somebody else's actions. So, for example, imagine that Congress passes a law that says that people over the age of 65 have to go through special security measures when they go to the airport. Well, I may think that that law is wrong. I may think that that is a terrible law and that that law is in fact unconstitutional. But I am not over the age of 65. I have not been arrested under this law. I have not been forced to submit to additional security screenings under this law. I am not even about to turn 65, and maybe tomorrow I will have to be exposed to these additional security screenings. So I haven't actually been hurt by the law. The fact that I don't like it or think that it's wrong is not enough to confer standing on me. The reason that we insist that the person who is bringing a lawsuit or bringing a charge is the entity that was hurt is because we want to make sure that the arguments or explanations that are being given to the court are the best possible arguments. So if we go back to this idea that after the age of 65 you have to undergo more rigorous security screening, if I, as someone who is a ways away from being 65, were to bring that lawsuit, I may not understand the full ramifications of what it's like to be a 65-plus-year-old person who's undergoing additional screening. And because it doesn't affect me directly right now, I may not do the best job of actually representing the interests of somebody who is affected by the statute. So we want the person who is hurt, the person who has the most to lose, the person who has the most skin in the game to be the one who actually brings an issue in front of the court. Not only do you have to be the injured party, but in addition, you have to show that your injury is the result of the challenged action. So again, perhaps I think that this statute involving being screened over the age of 65 is terrible, and I go and I make a big fuss at the TSA screening section at the airport, and I get arrested for disturbing the peace. So I have sort of indirectly been harmed by this statute because it was the statute that made me become belligerent, and my belligerence got me arrested. But that isn't really causation. Even though I've been hurt and arrested, my injury is not directly because of the statute. It's because of my own behavior. It's because of my response to an issue, not because of the statute itself. Finally, your injury has to be what we call redressable, which means that there's something that the court can do to help you. One of the most sort of famous standing cases is a case called Newdow. The Newdow case involved a law that required children to say the Pledge of Allegiance in school. And Mr. Newdow did not like the law because he was an atheist, and he felt that it was improper for the school to require his child to say the Pledge of Allegiance and include the language "under God." So he claimed that this was effectively the state establishing religion, forcing religion on his child. And so on his child's behalf, he brought this lawsuit. The case, he actually won in the lower courts, but the case went up to the U.S. Supreme Court, and the U.S. Supreme Court said, wait a minute, there's a problem here. Mr. Newdow did not have legal custody of his child. He and the child's mother were divorced, and Mr. Newdow had visitation rights, but his ex-wife was the one who actually had legal custody of the child. As a result, because Mr. Newdow did not have a legal stake in his own child, in this particular instance, he didn't have standing to challenge the statute that required his child to say the Pledge of Allegiance. More recently, there was a fair amount of controversy over the 2020 presidential election, and the state of Texas actually attempted to file a lawsuit claiming that the vote counts in several other states had been improperly conducted, and that this somehow affected the state of Texas because these other states were declaring Joe Biden the winner of those states' electoral contests, when in fact it should have been Donald Trump. It's an interesting argument, but unfortunately the state of Texas doesn't have standing there. If somebody who lived in Pennsylvania or somebody who lived in Georgia had wanted to bring a lawsuit challenging the election results, then it's possible that they could have done that. Certainly if the individual candidate, if President Trump had wanted to bring a lawsuit, he might have been able to do so. But the state of Texas didn't have any skin in the game. While certainly the people of the state of Texas care about the overall election results, they don't have a direct stake in how the state of Pennsylvania conducts its election. And so as a result, the state of Texas doesn't have standing. Another issue that we have to address when we're looking at the issue of justiciability is whether or not there is a case or controversy. Ultimately, the Supreme Court, or the courts in general in the United States, typically do not issue what we call advisory opinions. So, for example, let's say that the U.S. Congress passes a law and the president is unsure whether the law that they have passed is constitutional or not. So the president's like, I don't know if I want to sign this law. It may not be constitutional. I just don't know what I should do here. You can imagine that the president might want to go to the U.S. Supreme Court and say, hey, ultimately you guys are the ones who are going to decide if this law is constitutional. Why don't you just tell me? Tell me now. And we can skip over the process of creating a new administration to implement this law and spending tons of money on enforcing this law and actually arresting somebody perhaps for violating the law or fining somebody for violating the law. Let's skip all that and just tell me up front, is this law constitutional? That makes a certain amount of sense, but unfortunately, that's what's called an advisory opinion. The federal courts in particular will not issue advisory opinions. I should note that some state courts will, under certain circumstances. That's a matter of state law. But the federal courts do not. The federal courts will not issue a decision about an issue unless there is a party on one side of the case and a party on the other side of the case. There has to be an actual controversy between two individuals, between a corporation and an individual, between the state and an individual. There has to be an actual conflict before the courts will weigh in. Once again, the goal here is to make sure that when the court sort of wades into a legal issue, they're being presented with the best possible arguments on both sides. They want to make sure that the case has developed to the point that people really understand the implications of the situation, and make sure that there is somebody to represent both sides of the argument. A related issue is something we call ripeness, and this is this idea that sometimes a case isn't ready yet, that the contours of the dispute haven't really been fleshed out. And so it's too soon for the courts to make a decision on it. This usually comes up when the court has passed, when Congress has passed some sort of law, for example, that creates a criminal penalty for some act. And, Joe is worried that he might get arrested for whatever this criminal statute is. And so he wants to file a lawsuit about the statute before he's actually been arrested. And so the court doesn't want to weigh in yet, right? They want, again, to make sure that Joe has an adequate stake in the outcome because he's already been arrested, that we know what the actual implementation of the law is going to look like because the government has acted, they've actually put the law into effect. We know then what it means and exactly how it's going to happen. Before that, there's just not enough information, and we say that the case is unripe. By the same token, a case can be stale, and we call that in the legal context, we refer to that as being moot, M-O-O-T, not mute. Sometimes people talk about mute court, like silent court. That's not what they're talking about. Moot means that it doesn't actually have any consequences. One of the cases that I think is most interesting with respect to the issue of mootness is a case that came up a number of years ago. There was a very famous criminal defense attorney named Johnny Cochran. He's probably best known as being one of the defense attorneys who represented O.J. Simpson when he was arrested for murder. And Johnny Cochran was a very high-profile attorney. He had a former client who did not like him at all. And apparently this guy didn't have very much to do in his life because he spent most of his time standing outside of Johnny Cochran's office with a sign saying that Johnny Cochran was a fraud and a shyster. So Johnny Cochran started the process of suing this guy, his former client, suing him for something called slander or defamation, which is when somebody says something untrue about you that has the effect of damaging your reputation. So Johnny Cochran starts this process, and as the case is working its way through the court system on appeal, Johnny Cochran dies. His heirs, his estate, wants to continue the lawsuit in his name on the grounds that they want resolution of the legal issues. Unfortunately, from the Supreme Court's perspective, the case is now moot because you can't defame a dead person. So, which seems weird, right? Because obviously you can say bad things about a dead person, but the common law right to sue for slander, to sue for defamation, ends when you die. So even though this case had been working its way up through the courts and it was really interesting and people were watching it very closely, all of a sudden it's gone. And it's gone because Johnnie Cochran passed away. The court does sort of play a little bit fast and loose with this idea of mootness when it absolutely has to. So, for example, if we look back at the case of Roe versus Wade, which was decided in 1973, it was a case in which Jane Roe, that was not her real name, of course, but she had been pregnant. She sought an abortion in the state of Texas and could not get one because abortions were illegal in the state of Texas at the time. And so she challenged this Texas law, claimed that it was unconstitutional. By the time the case got to the U.S. Supreme Court, Jane Roe had had a baby, right? She wasn't pregnant anymore. She couldn't get an abortion anymore because that baby was born. That baby was a toddler. So the state of Texas argued that the case was moot. And the Supreme Court said, well, on the one hand, you're sort of right. Normally we would agree with you. But here's the thing about pregnancy. Pregnancy only lasts for 9 months, and court proceedings tend to last longer than that. If we require that the person challenging this law still be pregnant at the time we hear the case, we're never going to get to hear this case. We're never going to get to hear a case like it, because the person who sought an abortion and was denied is always going to be a mother by the time this case reaches us. So they make this special exception for situations that are recurring, right? You can get pregnant again, it's likely to recur, but that have sort of a natural sort of expiration date, like a pregnancy. Okay. So the last issue that we want to address when we talk about justiciability is something called political question doctrine. Political question doctrine is something that a lot of students really struggle with. They can sort of understand the idea of the court wanting the right people to be in front of them, wanting the issue to be well developed, wanting the issue to still be live and not moot. A lot of that makes intuitive sense. Political question doctrine doesn't make quite so much sense. But here's the thing. There are some types of questions that the courts consider to be too political, that they are things that ought to be resolved and determined by the other branches, and the courts just don't want to go there. They think that this is not an appropriate place for courts to be making decisions. So the idea of political question is not very well defined, to be perfectly honest. It's one of those things where you can sort of anticipate, I bet the court's going to find that this is a political question, but it's really hard to know. It's something that the courts use when they want to and ignore when they want to. But some examples of the way the court evaluates political questions. One is that they look at whether, and this is the quote, that there is a textually demonstrable constitutional commitment of the issue to a coordinate political department. Those are a lot of big words, but what this means in short is that the language of the Constitution gives this issue to one of the other branches. So probably the best example is the issue of impeachment. The impeachment process belongs to Congress. It is up to the House of Representatives to issue articles of impeachment, and it is up to the U.S. Senate to decide whether to convict somebody on the basis of those articles of impeachment. The process is entirely dictated by the text of the Constitution and the rules of Congress. And so the court has said repeatedly that if, say, for example, the president were impeached, he can't really go to the courts and challenge his impeachment. If he's removed from office by the Senate because of an impeachment, he cannot go to the courts and ask to be reinstated. The courts just won't go there because the entire impeachment process is something that is textually committed by the Constitution to Congress, not the courts. There is another sort of test that the courts sometimes use when they talk about political question doctrine, and that is when there is again, this is the quote, a lack of judicially discoverable and manageable standards for resolving it. What this basically means is the court doesn't really know what test to use. The sort of classic example of this issue is something called the Guarantee Clause. This is another provision of the Constitution that says that the people of the United States are guaranteed a Republican form of government. What exactly we mean by a Republican form of government is a little unclear, right? The Constitution doesn't specify what that means. And the courts have said, we don't know either. This is not our business. We're not going to wade into this matter. This was an issue many years ago in a case called Luther versus Borden. The state had a fairly archaic system of government, and there were a number of people who felt that it was not adequately democratic, that it was that the system of government was not what we would consider a Republican form of government, was not representative, etc. And so they called a popular constitutional convention, and they essentially created a shadow government, a government that was constituted in a way that the people felt was more appropriate. The original government obviously took issue with this, and they declared martial law and insisted, and sort of smacked down this insurrection. And one of the sort of rebels in this situation was a guy named Martin Luther, not to be confused with the religious Reformation figure from medieval Germany. But instead, this Martin Luther claimed that the Constitution guaranteed the people a Republican form of government, and since his state government was denying him that Republican form of government, he should not, that government was illegitimate, and it couldn't then prosecute him. And the Supreme Court said, no, we're not getting into this. It is not up to us to decide what a Republican form of government is. We have no sort of set standard to measure the legitimacy of a government. We're just not going to touch this with a 10-foot pole. The last sort of test that the courts use when they talk about political question doctrine is this: whether there is the potentiality of embarrassment from multifarious pronouncements by various departments of one question. Again, that's a lot of big words, but basically what this means is the court isn't going to get involved if the United States as a whole is going to look bad because there is a conflict between the courts and either the Congress or the president. The classic case where this particular issue was used, or this particular sort of description of political question doctrine was used, was after arguably the end of World War II. An armistice had been called, there was a ceasefire, and hostilities had effectively stopped in the European theater of war. The president, though, wanted to send somebody out of the United States, exclude them from the United States as an alien, as an alien combatant, basically, meaning that this was a person who was on the side of a different government in the course of a war. And the individual that he wanted to deport said, you can't do that because the war is over. You can only exclude alien enemies when a war is active and the war is officially over. And the Supreme Court said, again, we're not going to decide this. It is not up to the courts to decide when a war has ended. That is something that is better decided by the president. It's not textually committed to the president. Right? There's nothing in the Constitution that says that the president gets to decide when we are and are not at war. In fact, if anything, the right to declare war is actually given to Congress, not the president. But in either event, the court said, we are not in a position, as 9 people wearing black robes, we are not in a position to know whether the current international climate is such that we are at war or we are not at war. That's just not something we can decide. So again, the court tends to invoke political question doctrine when they want, for whatever reason, to avoid an issue. And they're not really sort of consistent about the way that they do it. But these are the sorts of questions that the court gets at when they invoke political question. They're looking to see whether this is an issue that courts should be involved in, or whether this is something that a different branch ought to be deciding, because it's just too political. So again, just to sum up, all of these issues of justiciability, standing, which is sort of the identity of the person who is coming to the court and asking for help, case or controversy, which has to deal with sort of the development of a contentious fight over a particular issue, and political question doctrine, which sort of defines a realm of cases that are outside the reach of the court. In all of these issues, the court is looking at whether this is an appropriate time, place, context issue for courts to be involved in resolving disputes.